I'm Dr. Barry, licensed psychologist, and here I share legal and entertainment news from a psychological perspective. If you know nothing about the Sarah Boone case, please, I have some videos tagged below that go into this case. I think a lot of us have possibly have already seen the hearing that she recently had, and the judge set amazing boundaries with her. And I want for us to take a look at this. So I'm just going to highlight some of these comments. The judge is pretty merciless, but he does it in a kind way, I think. Like to me, he was firm with her and he was consistent. And it was interesting because I heard the prosecution mention plea deals a few times. So it sounds like they might be open to a plea deal with her. And in my opinion, I don't think she has what it takes to fully and accurately defend herself. She doesn't understand the criminal like there's so much that she just doesn't know. And the whole I don't know is not going to be enough. The judge did add an extra week to the potential trial starting October 7th. And I think he knows that like there will probably have to be pauses to explain things or like that she I don't know. Like I think the judge understands that it might take longer with Sarah Boone being pro se. So welcome, welcome. Thank you all to everybody that's watching live and for anybody that will catch up on the replay. I have 3 videos planned out for today. So after this one, we're going to talk about Olympic athletes and resilience. And then after that, we're going to talk about school based anxiety. And then I'm going to take Saturday off. Today is my birthday, and I'm going to take the weekend off. I'm working today, and so I'm glad to get to hang out and share this with you all today. All right. So I wanted to start with this beginning part because you're going to see her look over at the cameras. And she's going to say later that she doesn't like the fact that the cameras are there and that she's concerned about I don't know, that she's concerned about things getting out to the public. I don't know if that's true. I don't know. You see that little smile over to the cameras? Uh, And so she says she doesn't want the cameras there, but to me, a lot of her body language and everything, and a lot of her behavior is kind of like, watch the show, like, get ready for what I'm about to do. And in my opinion, she displays a lot of narcissistic like traits where she builds herself up. And I think a lot of her possible personality traits are why I don't know if she will take a plea deal, even though a plea deal that could potentially take years off a potential sentence or maybe drop one of the charges, I don't know if she's going to agree to it because she does not want to be guilty of second degree, capital M, or any of that. I don't know that she'll actually agree to it, but we shall see. We shall see. So I'm going to fast forward so that to where we get started with the hearing. The judge is going to go over with the jail because they have to get things prepared to send because they have to work out a lot of these processes with Sarah Boone being incarcerated and also representing herself. So let's go on ahead and play from here.
Are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those 3 motions?
Okay. So the court, because she filed motions and I shared a video of a lawyer going over those motions. I can't let Sarah Boone take over my entire channel, but I can cover it when major things happened. So she submitted motions, and the judge is pretty much responding to them, saying that because she asked for money for witnesses, but she didn't identify the amount and she didn't identify the witnesses. She wanted money to pay witnesses, but like she didn't say who needed to come. And so the judge is just explaining the process to her.
And do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date, once I have that information, to revise them.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
And the way that she speaks, so she can be, in my opinion, she can be passive aggressive where she's not clear in what she wants. And when you're a lawyer, you have to say, I object, and this is why. And it has to be based in facts. And it can't be based on feelings or your perception of the facts or any of those things. Like, it has to be based on the law as well. And she might have been able to ask for a continuance, for a delay in the case, but the way that she says it, she doesn't actually ask for it in a way that's legal. Because sometimes the judge will say, I don't know what you're asking of me, because she's not coming out and actually saying the thing. And Dog Mom, I really do feel so bad for George's family and how this has been 4 years that she has drug this out, and, we are gonna have a whole bunch of hearings from now until October 7th, because every time she has a question for the judge, at the end of this hearing, she's gonna ask for the judge's email, and he is gonna say that she can have, I think, like, I don't know if it was his clerk, but that he can have someone at the office, that she can have their email, but she can't have his direct email, because I think she's going to just kind of, why don't I get this? This isn't fair. That isn't fair. I don't have internet. I don't have this. I don't have that. Y'all are violating my rights. And these are preferences and they're not actual rights. And so, yes. Uh, let's see. And so, Dog Mom, some of the digs she throws are not so subtle. Like, she flat out says that people are lying and that there are issues happening. Ritz, I agree. She comes off incredibly emotionally immature, especially when she doesn't get her way. I honestly think my now 7-year-old has more emotional maturity than she does. And that's just my general thoughts, because when my 7-year-old, when he starts going, nah, nah, I just ask him, take a break, just ask for me. And he's like, oh, yeah. And then he'll just ask for what he wants, and he's able to be easily redirected. He doesn't take it personally when I redirect him. She is not easily redirectable based on what we've seen. And so, let's see. And yeah. And you're being nice, Ritz, saying teenager at times when she's not getting her way. And I do think a part of it might be a manipulation tactic where she she might think, if I throw a big enough tantrum, I can get my way. If I act this way, this is how my fans will see how unfair this is, and the world will see how bad the court is treating me. And that's not how anyone sees it. It sounds like she wants internet access. So it will be interesting if she does get like full internet access. They will track anything that because she's representing herself. I wonder if they can still track like what she searches and all of that. I don't know. They should, but I don't know.
With regard to the defendant's motion for reservation of proposed costs hang on. With regard to defendant's motion for reservation of proposed cost to acquire expert witnesses for the defendant's defense in trial, dated July 18th, 2024, and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert.
So they're basically just saying that they can't go off this general motion because she kept saying to be determined. And Dog Mom, you said that she really does believe her intelligence supersedes everybody else's, but then she will try to downplay her intelligence, because what she does is she then says, "Am I competent to represent myself?" And she understands the like who the lawyer is, who the judge is. Competence to represent yourself, it's not, do you understand the law? That's not what that competence is. And she hasn't shown signs that she's incapable of making this decision. And it would be like if a defendant, like, wow, there's one, the mother whose child, it's a horrific case, where the mother's child was found also in a suitcase. And she has been engaging in very erratic behavior where she does not seem to be connected to reality. And she's refusing court appointed attorneys. And they are going to have a competence hearing to see, is that individual competent to represent herself? Because she's likely, like, she appears to be showing signs. This other individual, not Sarah Boone. Y'all know me and names. I've covered the case before. I'm hideous with names, but in that other case, that individual appears to have some psychosis or some severe mental health conditions that may impact her ability to say, "I don't want a court-appointed lawyer." Sarah Boone hasn't shown any of that. And somebody did just ask that I talk about alcoholism and its effects on the brain. So I have covered this case multiple times. And one of her attorneys wanted to talk about alcoholic blackout, and that as a possible defense. I covered that in a previous video. Right now, she is likely sober, likely. She wants to get out. And if she did get out, because of her history with alcohol, she would be at risk to potentially use again. And even if a person is sober, sometimes the alcohol help them cope with stress, or it help them manage themselves a little. I don't like, for some people, it did something for them. And so there is a term that's sometimes used where a person, even when they're sober, they're still showing signs of issues. And sometimes we say like dry drunk or something like that. Okay. Let's keep going.
So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial, dated July 18, 2024, and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
So we all know she is going to have a big issue with this because she has put in all caps, I do not want to represent myself. But her behavior forfeited her right to a court appointed attorney. That it's not a right, like that you can do whatever and, make claims against attorneys and write a trillion letters and do all of those things, and you still have a court appointed attorney. That due to her behavior, that's why she doesn't have a court appointed attorney. I didn't real But it makes sense to me that standby counsel, that's exactly what they're there for. So when the defendant says I want to represent myself, that person can just step in. I thought they did kind of answer questions, but I guess that's not accurate. And every state might do that different. This is what is happening down in Florida.
Ma'am, the courts had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635.
So the judge not only said no, the judge has receipts. Like the judge he's just reading off the the court case because they are maintaining an accurate record to make sure that when she appeals that they didn't violate her right in any way. And so they've already looked at the case law to see that she does not have a right to standby counsel.
At pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253, at pinpoint 258 from 1984.
So I just want to come up pull up Sarah's comment because I don't even think she wanted an administrative assistant. I think she wanted a Saul Goodman from Better Call Saul, or like I think she wanted an attorney that would do anything to prove her innocence with no disregard for, with no regard for the law or like what's appropriate and what's not appropriate. Like I think she just wanted somebody that would do anything she said and believe her. And because it's not that her previous attorneys didn't believe her. I think the previous attorneys just knew that what she was trying to say, that it's not fair, it was an accident, that some of those things weren't gonna be enough when she's charged with second degree, capital M. And so, ah, exactly, Rachel Ann. If you don't see things her way, not only are you wrong, but you were like actively against her. And the way that she talked about Miss Cashman's attitude, and I think Miss Cashman was just setting boundaries with her. I'll be very interested to see her next letter to the judge because I think she's going to feel a lot of this was unfair and that she wasn't heard. Because when she doesn't get her way, she equates that with not being heard. And there's a very big difference. I can hear you disagree and not do exactly what but I heard you. I understand you want a lawyer. I understand you don't want to represent yourself. I understand that you don't think you did anything wrong. Here's the 16-page document that the judge wrote that said this is how you forfeited your right, including when the judge ended with the number of days they've been waiting to proceed, like because she's always thrown that out, the exact number of days. Like she's always thrown that out. When the judge did that back, I was just I was clapping in the background. I could not believe it, but I like Judge. I like this judge.
The court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel. The court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order
16
previously
pages.
entered, your request for standby counsel is denied.
Denied.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I do not forfeit my rights. That was your judgment.
Okay, so I'm sorry. So I have a very dark sense of humor. Okay, so if you want to see this without the pausing, full link in the description. I, so she's not understanding that it wasn't that she said, it was her behavior that forfeited the right. It wasn't her words. She was saying she wanted an attorney, but then all her behavior was going against that. And the judge said, if you don't stop this behavior, if you can't play nice, you're going to forfeit your right to a court appointed attorney. And she effed around and found out. That's exactly what she did. She continued to play with Miss Cashman and the pretend judge. I have never heard a defendant say to a lawyer, to their lawyer, pretend like the judge is here and say that again, because the way you're saying it, you wouldn't say it that way if the judge was here. And she told the judge, and she was proud, like, oh my, look at how I'm trying to work with her. I was problem solving. I invented pretend judge, and she's not getting because she lacks insight. And so that's where, in one of my comments, I put individuals with these types of personality traits. The reason why they can be very difficult to work with is because they deny, they gaslight, which is they're the problem, but they tell you you're the problem. They accept no responsibility for their behavior. They have no empathy for how their behavior impacts other people. So the claim she's made against those past attorneys, that those things could result in bar complaints if they were true. So if the attorney truly did lie to the judge, if that was true, and that's where the judge was like, give me an example of her lying to you. And Sarah's example was, she says that that I can't get bail, and the judge was like, that's not a lie. Like, you just don't like it. Like, there's a difference between things you don't like and a lie, and she's not getting any of it. And it can really be a defense mechanism where she can keep an intact sense of self. So individuals with narcissistic traits, so I've never diagnosed her. I don't know exactly what she has going on. Based on publicly available information, this is just my disclaimer for legal reasons, she appears to exhibit signs that are consistent with narcissistic personality disorder. And with individuals with that disorder, a part of their denial, it protects their very fragile sense of self. Like, if she really understood, oh, wow, I lost my right to an attorney because of my behavior. And that lack of insight can sometimes make it where they are very difficult to engage in treatment. So after all of this, I still don't, she doesn't think she's the problem. So there are other people, even other people that have narcissistic personality disorder, that might be in her same situation, that would admit, I was wrong. I messed up. I need help. And they would seek that help. She still doesn't think that she needs help. She still doesn't think that there's anything wrong with her. And so, uh, uh,
And also, I feel
I feel
I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying.
She's pretty much saying, "Judge, you got this wrong. You didn't understand, and you made a bad ruling because you don't understand," which is not the judge totally sees it. The judge gets it.
I'm my standby counsel, which thank you to him for explaining to me what specifically it is. I don't want to be pro se any longer, so I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing,
This judge, I and she isn't, in my opinion, in my personal opinion, she's likely more of a covert narcissist where you're not sure at first. Like, you don't really realize just how manipulative and conniving she might be until you kind of interact with her a little bit. At first, you might kind of feel sorry for her, and then you kind of realize, wait a minute, she has a problem. There are other individuals like Ali Abulaban who could not maintain his emotions, his behavior, to the judge in court with his lawyers. Like, he did not maintain himself at all. And he would, to strangers, he would just say things that were outrageous. Like, you clearly knew when first meeting him, like, ugh, there's a bit of a problem. So malignant narcissist, you can see them a mile away. Covert narcissist, you end up in a relationship with them and you're like, oh crap, like, this person has no empathy. Like, you don't realize it at first. You sometimes get pulled into their sob story and, oh my gosh, there's so many things that are going on. And Rachel Ann, if she was given a standby lawyer, she would try to treat that person like they were her actual lawyer, and she would just call them excessively and pester them, and because that's what she does to get her way. The way that she does it, and that's where I say it can be passive aggressive, because she's saying the words nicely, but there is a punch behind it. Like, she's saying it nicely, but she's telling the judge, "You don't know what you're doing. You don't know what you're talking about, and I know better than you." But she's saying it in a way that she's trying to sound like respectful. I don't know what, I guess the word might be respectful. She's trying to say it in a respectful way, but it is definitely an issue. So, let's keep going.
that seems to be in the realm of a Forfeiture inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Beretta hearing is in regards to competency as opposed to
Competency.
having understanding before you take someone's right away.
Forfeiture pertains to a criminal defendants seeking to represent themselves. Forfeiture was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know.
It's not so just so y'all know, like, the reason why I laugh is because it can be painful to engage with. So if this was my client, I would not laugh. Like, I would manage all of my emotions. I would set clear boundaries. This judge is being so professional with her, and he is giving her almost 2 hours to get every question she has, to explain things in a way that she can understand. Like, so I'm able to take a look at it, not as like her therapist or anything. I'm able to come in from this outside looking in. And that's why I just find it like, oh my gosh, just so wow. Because what she's saying is y'all should have determined if I was competent or not to represent myself. But she has to, all of her behavior has shown, like, with all of her letters, while they are, some people use the word delusional. And for me, it's her not accepting what she does not like. So it's not a delusion like she thinks she's the president of the United States, or she believes that the prosecution is, working for, I don't know, like it's not some clinical delusion in a psychotic way. It's more of a personality. She's not accepting things that she does not like, that she does not want. And yes, it is denial, it is gaslighting, it is manipulation. Because I think a part of her does understand exactly what the judge is saying, but she's trying to say, "Oh, I don't understand," to try to get the judge to change his mind, and he is not gonna change his mind. And yes, somebody else said defiant and oppositional. And it's in a way that can line up with a and with traits of antisocial personality disorder. The rules don't apply to me. They There isn't the same understanding of right and wrong, beyond just like an oppositional defiant disorder, like almost like an antisocial personality disorder. Those are just my general thoughts, general ideas.
what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So
To me, the judge did let her explain herself because he received her letter, and excuse me, and he was concerned with what she wrote in the letter, and he specifically asked her, "In what way are you in what way has Miss Cashman lied to you?" Like, the judge specifically, she asked for specifics, and everything she said was just general disagreements. And in my opinion, Sarah being demanding and uncooperative and, ooh, those types of things, and Miss Cashman doing everything in her power to try to make this difficult client, lawyer relationship work. And even with all that Miss Cashman did, Sarah still on two different occasions got up and left. And then likely probably, like, was demanding of wanting her to come in person and do all these things, and nothing was ever good enough. And one of her former lawyers said, "No lawyer will ever be good enough for Miss Boone." And those words just stuck with me.
now my belief was that the evidence or the Ferretti hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. In my opinion, I felt
And the letters aren't why she lost her right to counsel. And the judge clearly outlined the behaviors that she did. It was pretend judge, the way that she spoke, the way Sarah spoke to Miss Cashman, and, alleging that people were lying when there was no evidence of any lies, and Sarah walking out of meetings, demanding, unlimited access to the lawyer. Those are the reasons why she forfeited her right to counsel.
that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
And she's trying to say this is retaliation from the court based on her letters, and it's just not. Like, these are just consequences. And I don't know that Sarah has had true consequences. And these are consequences.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings.
So somebody mentioned that she seems, this one right here, she seems more humble than before. And honestly, I think she knows she kind of has to play nice to make things work with the judge. She is now the lawyer representing herself, and she can't engage in the type of behavior that she was doing before. In my opinion, when she had the attorney there, her language would get very erratic. She would not, but like erratic, just saying, she would just say off the wall stuff, and she would do very off the wall things. It sounds like she's trying what she can to make this work. It does. And that gives me some hope that the trial won't be like completely Daryl Brooks bonkers. Like I don't, because a lot of people are saying she's worse than Daryl Brooks. In my opinion, Daryl Brooks played this role, and he was like trying to look bipolar and trying to look, you know, just he was all over the place. And to me, he came across menacing and scary to even the jury. He would menace towards the judge. Like he was doing all of those things that did not help him at all. He was found guilty. I don't see Sarah engaging in those types of behaviors. I do see her making like random objections that aren't backed by law. Her, you know, constantly asking the judge to explain things to her, or that she doesn't understand, or saying that this isn't fair, or reiterating that she never forfeited her right for an attorney. I could see her doing that kind of stuff.
Board's determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Yep.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys.
That is a huge accusation. She's accusing the attorneys of perjury. Like that's where her behavior gets reckless, in my opinion.
And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware.
Because she didn't, what she's doing now is just banter. It's not a legal thing. So her just saying, I don't like that you did that, I'm not going to revisit my earlier decision. Like this judge, the way he set these boundaries, I hope that they play this in law schools for like future lawyers, future, judges, for people to see like this is how you handle a difficult defendant. And to me, he is managing his emotions beautifully. And I've talked about Darvo, Deny, okay, I always have to look it up because y'all know me and words sometimes. Yes, it is. I always remember the victim. So there you go. It's deny, attack, reverse victim offender. That is classic Darvo. And that is deny the behavior, deny what you did, attack the individual doing the confronting, reverse the roles of victim and offender. And she tries this, and the judge just does not go for it at all. He just doesn't. And I think he did a phenomenal job throughout this entire, because we're only 17 minutes in, okay? We're only 17 minutes in. This went on for an hour and 47 minutes, okay?
That is my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
And he's letting her say, okay, you don't like that opinion. Okay, you're entitled to that. That's okay. Now we're gonna move forward.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of
She's going to get upset about how they're going to try to view the files, and she's going to want it to not happen in front of the cameras, which is understandable because if they played all of the evidence that the state has on court TV, that could potentially bias a jury pool. And so she sometimes, broken clock twice a day, you can still be right, can be wrong. And so she did have a good point with that, and the judge was going to look into what they could possibly do. Fast forward.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense to me.
That does make sense, yeah. And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just.
I'm going to fast forward.
The idea. And that's proceeding you, if any, and that's just at the. No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the
The interesting thing is, I don't know that Sarah Boone is going to know how to object correctly to certain evidence coming into the case because she's going to get all of her discovery. And a good lawyer is going to try to figure out, they're going to try to get that recording on her phone thrown out if they can. To me, that's the most damning piece of evidence that the state has. They might try to get the police interrogation. Like, a lawyer is going to try to get the most damning evidence thrown out if they can, if their rights were violated in any way, but they're going to back it up with law. It's not just going to be, I was in a emotional state and they shouldn't have asked me those questions. That's not a legal reason. And so I think that's part of what's going to come up. When the state is going up against the defendant defending themselves, it can just create so many issues for potential appeal. And the lawyer, has talked about the fact that those cases can go left really fast. And lawyers would rather go up against another lawyer versus going up against the defendant, because she's not going to know. Like, you can't just watch court TV and figure out how to be a lawyer. You just can't. um, Maybe it's cold inside the courtroom. I don't know. The judge has on the robe. Maybe they keep it cold. She does seem to engage in some addictive behaviors. I would agree with that. There is footage of past times the police had come out to the house for alleged DV between her and George. And in those cases, Sarah sometimes is saying the exact same words of saying we were having a good day, and like almost some of the exact same words that she said during on the day that his body was found. She said in some like previous videos. Oh, all right. Let's keep going.
laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality. It is all done in the courtroom with everyone?
She has a good point.
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced.
Because it's almost like lawyers meeting. It's like she just so happens to be the defendant, because they have to show her all of the discovery, and it's more like a lawyers meeting than like a defendant, a trial, a hearing about a defendant or something. And so they're going to work all that stuff out. At the end, she gets upset about the boxes and wants the boxes, and the whole hearing, it's just, she's going to ask for a 30-minute session with meeting with someone at the jail to discuss her internet access and just other concerns that she has. She said that she has found a way to possibly have some of her paper discovery securely in her office. So they're going to let her private investigator take the boxes back. It's just, this is going to be a little bit messy. This is going to be messy. I saw a question that I wanted to address because somebody said, yes, Woman of Steel, if Sarah had asked for a lawyer before her police interview, she might be in a better shape right now. Who knows? She got herself in a pickle. And I think she was used to the police being on her side, her being able to make George look like the bad one, but she didn't even do that. And in this case, she was just like, I don't know what happened, but the different stories that she told, it didn't make any sense. And I think it's in the 911 tape where she says that she zipped him in the suitcase. And the neighbors allege that they heard like loud something that might have been the suitcase going down the stairs. He has injuries that aren't consistent with just only being like his injuries are a bit suspicious. And I think the state is going to have their idea of what might have happened with that. And she's going to have evidence for why those things aren't true or why the state isn't proving their case. And I don't know if she's just gonna say, "We were having a good day. I don't remember what happened. It was an accident." Because, I don't know. I don't know. For me, if I was on the jury and that video of that she recorded on her phone, because the police asked her for her phone because they just wanted to, I don't know why, but they asked her for her phone and she gave it to them. But they found the video that she recorded on her phone. And at the end of this, they're going to talk about if she wants her own investigator to go through the phone, that she can do that. But her desperate need to be understood, she will not, like, she's going to talk. And I do think that she's likely going to testify on her own behalf. I think she's going to want to tell her side of the story if this does go to trial. It sounds like the prosecution is willing to discuss a plea deal. I do hope that whatever they're discussing with her, that they've discussed it with George's family to make sure that that they're okay with this as well. She Oh, it's my understanding that their relationship was incredibly toxic and his family wanted him away from her. And um my heart just really breaks for his family. Um okay. Thank you. So you say she doesn't have a desperate need to be understood. She has a desperate need to be the center of attention. And I think she would see those two things as the same things. Yes. She gave them the phone to see her prior bruises to demonstrate that she was the victim. Yep. 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 And she does not accept responsibility for anything. And I don't think any of that will play well to a potential jury. I don't think it will. And there are allegations that there are people in the jail that are trying to give her, like, advice and stuff, but, I think Patricia Cashman would have been the best possible, like, person that could have worked with her and tried to make sure that the state proved their case. I think Miss Cashman probably was her best bet. I do think she's in a huge disadvantage representing herself, and she's finding that out. The fact that I think they're going to try to review some of the discovery with her in a classroom at the jail, and it's going to be recorded. They're gonna try to accommodate her as best they can, but this trial is definitely going to proceed. So I'm gonna see where we are with this and then see what we do next.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them.
In her
So I'm
letters.
not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by sergeants.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach.
And every time she says, "Help me understand," that's where I say she can come across passive aggressive because while she's saying, "Help me understand," it's almost like she's saying, because at times she plays down her intelligence, at times she plays it up. And it comes across passive aggressive to me personally, but it might just be the rest of her behavior that I'm filtering this through as well.
By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked.
It's been 4 years. So this question says, do you think she'll gain any self insight through this process? I think she is entrenched in her beliefs, and none of this has changed her mind and her behavior. I don't think any of this gives her any insight. Uh, yeah, I don't think so. I'll be interested to see if she is found guilty, to see what her pre-sentencing report says and the risk level that they rate her, because I think she's going to blame everybody else. She's going to talk about how horrible it was she had to represent herself. Like, I think she would just go on and on about all of those things, and I don't think she's ever going to accept responsibility for her behavior. And people keep saying 16. It sounds more like, it sounds young, like it sounds younger than that to me. But it's this baby voice that I think once again comes across manipulative to me. To me.
By you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain.
So I'm just gonna in previous letters, she said that she did not have room, that she did not have space, that if she did have something, any of her discovery in her bunk, that she couldn't keep it confidential. Like, those are things that she had said. And now she's completely changed her story.
And you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery of hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another.
He went over it thoroughly.
I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions.
She's not coming with solutions. She's coming with demands, in my opinion, but we'll keep going.
But are being misinterpreted and misconstrued, like my order, my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward, to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at.
So, great question, Sanders, because I did skip through a large middle part of this. So she was asking for those 2 boxes. She wanted her physical discovery so that in the middle of the night, she could like pull out stuff and read it. Because right now she can only have her laptop that'll have the discovery on it from 8 a.m. to 4 p.m. And after that time, she won't have access to her discovery to prepare for her case. But she had previously said that there are so many people in the jail and that she was concerned about people seeing certain stuff and that it wasn't confidential. That's why she didn't want to have her meetings with her lawyer in the open bay. She didn't want her lawyer to pull out certain information because she couldn't keep it confidential. And she's completely changing things in this moment. And so I think this is what she sees as solutions and options. What I hear are just manipulation and demands, but and the judge might say, "Okay, you found a process," because the judge is going to give the 2 boxes back to her PI, and they're going to see if the jail can accept those boxes and keep up with them. But she previously said that she thought some of her phone calls were being released maliciously and she did not trust the people at the jail, and she's going to like ask like when the judge gives the discovery. I'm going to go forward just so that you can see when when they give her discovery to someone, that she is going to get like she's going to ask them to make sure to keep it safe, to keep it private. And just is difficult. Very, very difficult. Um all right, so let's see where this is.
Time to our digital evidence deadline, which I hope to exceed well before 9.
Gonna fast forward.
Reader, and then
For counsel, that will be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that. So now if I don't have what I need or I'm looking for, how do I go about, I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy near download of my phone. If it could be brought to you for physical, with the other physical.
so again, that is going to be something that requires an expert. And then if you get a defense expert and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
And the state is even going to say that they're going to give her the name of somebody that can do this for her if she needs it. And so, yes. Uh I'm interested. I will probably have like a hearing a week. I could see that happening. This is a very, very difficult case. I do hope that it is resolved once, if it does go to trial October 7th. It was interesting to me to hear the prosecution mention possible plea deal negotiations, that they were willing to record and talk, and anything that comes out during that portion is not admissible in trial. And so, um that was interesting because I wasn't aware that the state was still open to any potential plea deals. I don't know that we know much about her childhood. I would suspect that at minimum, there was likely, she might have felt overlooked by family. She has a brother that has security clearance and, is doing well. And so I don't know. How old is Sarah Boone? Ah, okay. So somebody said that she might be about 40, not sure. So I turned 42 today. Um, so if I am older than Sarah Boone, I don't know if I am or not. Wow. Oh, wow. So she's 47. There we go. So I am younger than Sarah Boone. So I don't know. Wow. The first week of trial is the week of her birthday. I wonder if she'll mention that in front of the jury. I feel like she probably would. Wow. 10/10/97. It's 1977. Wow. Wow, wow, wow. All the videos are terrible, but in particular, I thought the video from when the police arrived at her house and were interviewing her, that one is just ugh. And then the police interrogation, and then of course the video she recorded as well. Somebody said it's 42. So I don't know. I don't know. Lots of different ages in the chat. I don't know. And so we are going to be talking about the Olympics and resilience, specifically talking about Simone Biles and a few of the other gymnasts and track and field athletes, and we are going to do that next. If you don't want to go to that next stream, I hope you enjoy the rest of your day. If you're going to head with me over there, I'll be starting that stream in just the next few minutes. I hope you have a great day. Bye.